Hey everybody, this is Tracy here with another edition of A View from Tracy's Point. And it turns out that Daryl McDavid has tried to subpoena Jim DeRogatis, but Jim DeRogatis said he ain't coming, y'all. He done lawyered up and they done filed a motion saying, he is protected under the First Amendment and the Fifth Amendment and probably some other amendments, and that, journalists don't have to reveal their sources, and that enough people have testified as to his role or the videos, the authenticity of the videos, that he shouldn't have to come in. But Jim, we don't know if that's what they want to ask you about. They might want to ask you about some other stuff that you put in them books that people say that you was lying about. We don't know. We need you to get on the stand so we can find out. Okay, so guys, hold on. I thought it was Jennifer Bongine that had subpoenaed Jim, because remember in the beginning they was like Jim was subpoenaed, Michael Avenatti was subpoenaed, one other person was subpoenaed, but then the government closed. They closed a few days ago, said they was done after 9.5 days of testimony. So now the defense said, we'll call him up here and see what he has to say. But anyway, hold tight. I'll be right back, and then I will read his motion from his attorneys saying that he should not have to testify. Okay, so I know I haven't been on top of the transcripts. I do have the transcripts up to the 29th, and I really am working on getting those out. I know you guys are tired of me saying that, but I do have something going on in my personal life, which is what's hindering me from having time to get this stuff done. But in any event, I may have done a video last week and let you guys know that the prosecution has rested their case after 10 days. They didn't even have 10 complete days of testimony before they rested, and then the defense started presenting their case, and they were supposed to pick back up today. So we are now in the defense's portion of the case, and it was supposed to wrap up this week. And so now with the courthouse being closed today, we're not sure if it's going to wrap up this week or next week, but the case is definitely coming to a close. And so there was a lot of speculation that Jim DeRogatis was going to be called, that Michael Avenatti was going to be called. It was one other person that they were saying, several other people that were supposed to get called to testify who did not testify. And so Jim DeRogatis was actually subpoenaed by Jennifer Bongine. Now, I don't know if he was subpoenaed by the government and then the government decided not to call him. So then Jennifer said, we're going to call him, or how that happened. But now he has lawyered up, and he said he's not coming to testify because he doesn't have anything relevant to say, even though he has had a whole lot to say over the past, 15 years about Mr. Kelly. Well, maybe not that long, but anyway. So anyway, this is his motion. Emergency to squash subpoena to reporter and or for protective order. It says, now comes non-party journalist Jim DeRogatis and the New Yorker magazine to respectfully move this court pursuant to Federal Rules of Criminal Procedure 17C and the First Amendment, U.S. Constitution Amendment I don't know if that's one or I think one. Yeah. Free speech. Okay. Amendment 1 to squash the subpoena served upon him in the above captioned case by defendant Daryl McDavid or for protective order in support thereof. Movements state as follows. Okay, the article I read said that Jennifer Bongine has subpoenaed him, but this looks like it's saying Daryl McDavid. So in any event, one, Mr. DeRogatis is not a party or government witness. He is instead a reporter, music critic, author and associate professor at Columbia College, Chicago. Child, he's somebody professor? Like, who's sitting in a class listening to him? So as a journalist, he has reported extensively on defendants from the beginnings of defendant Kelly's career and throughout the present trial for news organizations, including Chicago Sun-Times and the New Yorker magazine. In 2019, DeRogatis authored the book Soulless, The Case Against R. Kelly, published by Abrams Press. And then there's a note at the bottom. It says they're citing a court case from 1972. If the newsman is called upon to give informal information bearing only a remote and tenuous relationship to the subject of the investigation, he will have access to the court on a motion to quash, and an appropriate protective order may be entered. Okay, so 2. The New Yorker, founded in 1925, is a Pulitzer Prize-winning weekly national magazine which has published some of the most groundbreaking journalism and commentary of the last 100 years, and very biased commentary, I might add. The New Yorker engaged DeRogatis to report on defendants, including extensive coverage of United States versus Kelly, Eastern District of New York, June 29, 2022. 13 articles DeRogatis authored for The New Yorker can be found at the following link. We don't want to read that. 3. On August 3, 2022, defendant McDavid served DeRogatis with a subpoena, Exhibit A, for trial testimony in this case. The subpoena did not include a check for witness fees, but DeRogatis was nonetheless instructed to appear on September 6, 2022. Because the subpoena is unduly burdensome, unreasonable, and oppressive under Rule 17c and the First Amendment movements, accordingly request an order to quash the subpoena or a protective order. 4. The courts must always be alert to the possibilities of limiting impingements upon press freedom to the minimum, and one way of doing so is to make compelled disclosure by a journalist a last resort after pursuit of other opportunities has failed. Gulliver's Periodicals Limited versus Chaz, which was a case heard in the Northern District of Illinois in 1978. And see also Hare versus Z-Tech, which was heard in the Northern District of Illinois, July 24, 2006, requiring defendants to establish via proffer at trial that they have a real need for the information and that the information is not available from another source. Patterson versus Burge, which was also heard in the Northern District of Illinois, but in 2005. Surely some good justification should be advanced to justify subpoena or journalists regarding news gathering. 5. The foregoing principles apply to news gathering irrespective of previously published works or the confidentiality of sources, because the policy which underlies the existence of journalistic privilege would be equally undermined by compelling reporters to reveal factual information surrounding investigations. Neal versus City of Harvey, Northern District of Illinois in 1997, and United States versus Lopez in 1987. 6. Here, as demonstrated by the articles linked above, virtually all knowledge that DeRogatis has that may be relevant to the indictment in this case, if there is any such information, necessarily derives from his third-party sources with direct knowledge of the facts, and therefore would be inadmissible hearsay under Federal Rules of Evidence 802. C. Braun versus Lorillard Incorporated, which was a case in the 7th Circuit, 1996. Affirmed trial court's exclusion of reporter witness under hearsay rules. Because Mr. DeRogatis' role has been as an investigative reporter, compelled testimony also is invasive as to his news gathering methods and cumulative of the actual sources and their source materials. For example, movements understand that the court already denied defendant McDavid's motion to put his news gathering on trial with respect to alleged emails with potential official sources. See docket number 247. Movements further understand that during the case in chief, Chicago Police Department Detective Dan Everett authenticated the only physical source material plausibly at issue, a VHS cassette personally handed to the detective by a Chicago Sun-Times editor. And then let's go up here. They cite a bunch of cases in a note on the previous page talking about a claim of privilege that is rooted in constitutional rights with respect to gathering of news or in safeguarding reporters. Courts must balance vital constitutional and societal interests of freedom of the press. While the Seventh Circuit has not recognized a blanket federal reporter's privilege, it acknowledges that Illinois has First Amendment interests in protecting reporters. And then another case recognizing paramount public interest in the maintenance of a vigorous, aggressive, and independent press capable of participating in robust, unfettered debate over controversial matters and interests, which has always been a principal concern of the First Amendment. And so then it goes on and talk about an Illinois code. It says defining source as inter alia, the means from or through which the news information was obtained. Moreover, the contents of this source material was authenticated by witness Rishona and other sworn witnesses. And then they cite where I guess the document or the transcript is. Any further facts that might possibly be gleaned from journalists' outtakes were likely to be merely cumulative. And then number 7, the only pertinent exception to Federal Rules of Evidence 802, therefore, would be declarations against interests made by defendant McDavid to DeRogatis during the course of DeRogatis reporting, including for the New Yorker. Defendant McDavid, however, has represented that he will testify in his own defense and therefore may relate all of his on or off the record statements to DeRogatis, leaving DeRogatis in the potential position of impeaching his source or risking subsequent claims that he breached confidentiality, whether or direct examination or cross-examination by the USA or McDavid's co-defendants. Garcia, who is herself the subject of the interview, has failed to make even a preliminary showing as to the nature of the statements contained in the outtakes. Okay, well, who is Garcia? Oh, they just throwing stuff out here. Is that in the notes? Child, they talking about somebody, they just threw somebody named Garcia out there that we don't even know who that is. But anyway, number 8. Okay, let me read this note at the bottom before I read number 8. It says, if required to testify, DeRogatis requests that the court make a finding that the subpoena constitutes a waiver by defendant McDavid of any agreement to keep confidential statements made by McDavid to DeRogatis, even if admissible under Federal Rules of Evidence 804b3. Which let's just put it all out on the table. So number 8, the absence of a legitimate evidentiary need for testimony alone indicates harassment or intimidation. And then they cite some case or appeals court justice ruling, and says intimidation by subpoena or by individuals unrelated but sympathetic to defendants is of particular concern when coupled with prior acts and statements of a threatening nature that augment the undue burden of being compelled to appear to answer irrelevant questions about inadmissible news gathering activities. Number 9, to rebut an improper purpose, McDavid should first proffer A, that DeRogatis possesses specific information relevant or necessary to the proceedings. B, that a specific public interest would be adversely affected if the factual information sought were not disclosed. And C, that all other available sources of information have been exhausted. Then federal rules of discovery, showing that the sought after information is highly relevant and material must be specific. And then compare the Illinois, whatever the Illinois code is, requiring specific factual findings before divestiture of the Illinois reporter privilege can be ordered. So 10, finally, because multiple witnesses testified from their direct knowledge of the facts material to the case, this court should exercise discretion to quash the subpoena on the reporter. Defendant, and then they cite another ruling by a federal judge, Lopez, which said defendant in criminal case had not satisfied her burden of making a specific of how the outtakes she seeks are highly material to her case. Wherefore, for the foregoing reasons, journalist Jim DeRogatis and the New Yorker magazine respectfully request that the court exercise its discretion to quash the subpoena. Alternatively, movements request the court to enter a protective order requiring a specific showing by defendant that the prospective testimony satisfies the foregoing criteria under the First Amendment. And then B, finding that the subpoena waives all claims of source confidentiality that defendant McDavid may hereafter assert, or C, providing for authentication of previously published materials through stipulation of affidavit. And then there was a note on the previous page. Published reports include that a window of the DeRogatis family home was shot out after Chicago Sun-Times reported on defendant Kelly and threats concerning DeRogatis and his then 6-year-old daughter. Child, now that he trying to say he was threatened. Child respectfully submitted Jim Crazy Butt and some attorneys for the New Yorker and child. So what is this? United States courts. So they got a picture of the subpoena. Okay, and then what else we got down here? A picture of the subpoena, proof of service, and then another picture of the subpoena. Who submitted this one? Okay, this looks like the same thing. What y'all? Okay, anyway, child. So there you go. Jim DeRogatis saying he is protected under the First Amendment, that he don't have to testify. And so it is Darryl McDavid who is requesting his presence in the news article that I had earlier. Let me see. Let me go ahead and type that article on here because I think I did. Oh no, they said Darryl McDavid. I don't know why I thought it was Jennifer Bonjean. So it says attorneys for longtime music critic Jim DeRogatis filed a motion Tuesday seeking to quash a defense subpoena to testify at singer Kelly's federal criminal trial. The motion filed by DeRogatis and his current employer, the New Yorker, alleges that by subpoenaing the longtime journalist to testify, attorneys for Kelly's co-defendant, Darryl McDavid, are trying to out his news gathering on trial. So because DeRogatis' role has been as an investigative reporter, compelled testimony also is invasive as to his news gathering methods and cumulative of the actual sources and their source materials, the motion stated. Lawyers for McDavid, Kelly's former business manager, subpoenaed DeRogatis last month to testify about a purported sex tape sent anonymously to him at the Chicago Sun-Times 2 decades ago involving Kelly and Rishona Landfair. And of course, they didn't put her name in there, but anyway. DeRogatis reporting on that tape helped break the investigation into Kelly's alleged misconduct wide open, leading to Kelly's indictment and eventual acquittal charges in Cook County. DeRogatis was called to testify in that case, but asserted his First and Fifth Amendment rights and did not answer questions. The same videotape is one of several purported tapes at the center of Kelly's current trial at the Dirksen U.S. Courthouse, where Kelly McDavid and another former employee, Milton June Brown, are accused of conspiring to hide Kelly's misdeeds by buying back incriminating evidence and paying off and intimidating witnesses. Let's see. Lawyers for the defendants have repeatedly tried to call into question the authenticity and chain of custody of the DeRogatis tape, in part because copies were made at the Sun-Times before one version was turned over to police. Oh, okay, he made a copy. So last month, McDavid's attorneys also accused the former lead prosecutor on the case, Angel Kroll, of improperly communicating with DeRogatis in early 2019 using a burner email account, piedpiper312@gmail.com. That was attached to a pseudonym, Demetrius Slavinsky. According to prosecutors, Kroll had a short phone conversation with DeRogatis about possibly sharing the manuscript of his book, Soulless: The Case Against R. Kelly. Then had a brief email exchange. She did not respond to subsequent emails or voicemails from DeRogatis, according to prosecutors. DeRogatis previously told the Tribune that he was the one to initiate contact with federal prosecutors in an attempt to cultivate sources. That effort was unsuccessful, he said. Okay, so Angel Kroll knew better than to be talking to this idiot. Okay, so Angel never gave me a damn thing. No federal prosecutor ever did, he said. Kroll left Chicago in 2020 to care for an ailing relative and is no longer handling the Kelly case. Meanwhile, DeRogatis' 10-page motion to quash the subpoena stated that multiple witnesses had already testified as to the veracity of the videotape, making his testimony unnecessary. McDavid could take the stand in his own defense Wednesday in the final days of the singer's Chicago trial. He is expected to testify that one of the tapes he's accused of trying to buy back was, in fact, a video of Kelly and his then wife, not CP that prosecutors have alleged. McDavid had been slated to testify Tuesday, but the Dirksen U.S. Courthouse unexpectedly closed due to an unspecified operational issue. The delay means Kelly's trial will almost certainly stretch into next week. So guys, what do you think? Are you surprised that Jim DeRogatis is once again trying not to get up on that witness stand and get exposed for all of his manipulative reporting and other shenanigans that he has been keeping up? Go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.